So welcome everyone. Our next panel is going to speak to you today about issues and trends in ESG litigation, mass and class action litigation. And I'm gonna ask one of our distinguished panelists to explain to you what ESG litigation is all about. But before I do that, I wanna introduce our panelists to all of you. So with you on stage is Simon Walsh, and Simon is a litigation and arbitration specialist practicing with Cadwalader in London. Simon's practice includes advising multinationals and financial institutions on exposures to ESG risks, as well as advising ESG rating providers. Simon also acts in collective proceedings related to the misuse of personal data and was formerly senior investment officer for a fund in London providing litigation finance for collective claims in the UK, Australia, and Canada. We also have with us here today Daniella Strik. Daniella is with the firm of Linklaters in the Netherlands, and Daniella heads the firm's dispute resolution practice in the Netherlands. She advises on litigation, including mergers, acquisitions, and joint venture disputes, banking litigation and competition disputes, and on commercial arbitrations. She has particular expertise in litigation arising from cartels and is authority on directors' duties and liabilities. We also have with us today Anne Gron. Anne provides expert economic analysis and testimony in the context of complex commercial litigation, antitrust disputes, government and regulatory investigations, class actions, and damages estimations. She has testified and consulted on class certification in matters alleging price fixing, collusion, monopolization, and breach of contract in the context of commodity markets, financial benchmarks, insurance claim settlements, and insurance contracts. And Anne is with AlixPartners in Chicago, in the United States, Chicago, Illinois. So welcome to you all. And just to get us started, Simon, I thought perhaps you could tell us what ESG stands for and give us an overview of the types of ESG claims that are being filed around the world today.
Absolutely. So just to set the context, both for those of us who don't know what ESG is and also for those of us who are familiar with what ESG is, as a reminder of the sheer breadth of that term, because I think a lot of people, when they think of ESG, don't necessarily get past the E quite commonly. They think of environmental factors, such as climate change and greenhouse gases, but don't realize that actually it's an umbrella term that covers far, far more than that. So the E in ESG obviously stands for environmental, the S is for social, and the G is for governance. Three key factors that are used to measure the sustainability and ethical performance of a business, and as well as increasingly being used by businesses themselves in their decision-making processes to lay out their sustainability and ethical goals. It's also a generic term used in capital markets to assess investors, to assess the behavior of companies against various ESG factors to determine their financial performance. And as I've said, commonly, the ESG is thought of as a byword for environmental factors, but it is wider than that. What are the E factors, though? They're the environmental risks created by business activities that have an actual or potential negative impact on the environment. So that includes climate change, mitigation and adaptation, environmental management practices, waste disposal, energy. S is the social risks. So they refer to the impact that companies have on society, such as working and safety conditions, human rights, diversity, factors like that, modern slavery. And the G is for governance. So governance risks concern the way that companies are run. That covers anti-bribery, corruption, financial crime, and data protection, importantly. And to address increasing sort of social and political concern about these issues, there's a growing and enhancing regulatory framework that's growing up around ESG, with the EU, for example, introducing several pieces of legislation, including what's called the taxonomy regulation, to set out really the standards that financial services providers are supposed to adhere to when they are developing financial products that they label as green or sustainable. Outside of that particular regime, many companies are issuing sustainability statements or including in their annual reports their ESG goals and making claims about their ESG performance. Regulators are looking at those more and more closely, their accuracy and the support for them, and asking questions about how accurate those statements really are and whether they can be backed up. There are risks around that, obviously from a litigation perspective, but also from a reputational perspective. It can damage brand, and it can also damage access to capital if the statements that companies are making about their ESG compliance are incorrect. So what kind of claims are they leading to globally? Well, there are climate change cases I think Daniella is going to speak about, primarily aimed at governments for failing to comply with their climate change goals and obligations. I think there are claims against Holland, France, and Belgium currently for failing to attain their greenhouse gas reduction goals, but also against private companies for their contributions to greenhouse gases and the damage that has caused to property and land. There are obviously famously class actions in the G space in relation to Volkswagen. Some people call that environmental. I think that's more of a governance case. The Dieselgate scandal has come across the UK from the US. And there are also lots of other governance cases in the UK, such as Tesco for failing to properly account for various items in its accounts, and of course in the data protection space, famously with the case of Lloyd and Google that was recently rejected by the Supreme Court. Other G cases are data breach cases, so here in the UK, and I think globally we've seen Equifax and British Airways as data breach cases. I think they're really the main trends. There are a few S cases in the States. There's a case against CBS. There are further G cases against Petrobras and Danske Bank for anti-bribery and corruption issues. But they're the main themes, I think.
Great. What kinds of barriers are you seeing to the prosecution of these cases, both in Europe and in the United States?
So the barriers, I think, primarily are how you assess damages in these cases. That's going to be a big issue. And especially if you look at climate change litigation, there's the question of how you attribute a specific company's environmental impact to the specific damage that's said to have been caused, even though there's increasing sort of attribution science around that. I think that's going to be one of the key barriers. In England, of course, we've got a procedural barrier in that the only real opt-out procedure that we have is representative action under 19.6, and that suffers from the issues that we saw last week in the Supreme Court. So I think they're the main barriers.
Great, thank you. And Anne's going to tell us all about how you might evaluate damages in the context of those cases. So we'll get to that in a moment. But before we do that, Daniella, let me turn to you and talk a little bit about climate change litigation. Obviously, climate change is at the forefront of many people's minds these days, and I know we are seeing a lot of litigation in this space. So perhaps you could tell us a little bit about the key trends in climate change, class action litigation, and the legal basis that parties are relying on to pursue those claims in the courts.
Yes, Simon started with a definition of ESG claims and then also referred to the climate change litigation definition. Actually, the United Nations Environmental Programme has defined it as cases that raise issues of law of fact regarding the science of climate change and climate change mitigation and adaptation. And that's important to set that out because there's also more broadly environmental litigation on certain environmental standards that may be invoked and where only climate change is relevant en passing. And those type of cases are excluded from the definition and also the trends I will be referring to. I think first and foremost, the quantitative trend is relevant to mention, because this whole phenomena only took off only in 2007. And then you see over the past decade, and particularly after the 2015 Paris Agreement, there have been about 1,000 cases. So that's twice as much as in the previous 2 decades. And primarily it started as cases against governments, as Simon said, but increasingly, particularly in the last 9 months, also corporates have been on the receiving end of that. And the Shell case, in that respect, the Dutch case, where Shell was ordered to reduce its greenhouse gas emissions very drastically, including the emissions from its customers, has really driven that. So what's the trend then in terms of relief being sought? Simon mentioned what is claimed against governments. So really you can distinguish the more systematic type of claims urging a change of policies, a very global systematic change. And this is referred to as strategic climate change litigation, as opposed to more non-strategic litigation that's really directed against very specific projects, or for instance, the litigation that was started in relation to the bailout provided to airline KLM, where the government was blamed for not putting forward stringent conditions in the context of climate change. And then growingly, as an anti-movement, there is also anti-climate litigation. For instance, Republican US Attorney Generals challenging certain climate change legislation, or corporates invoking investor-state dispute resolution mechanism for the protection of their investments at the back of changes in legislation. And then last but not least, the corporates that are on the receiving end. And the legal basis is really threefold. So first of all, the groups that are invoking national legislation, codified climate change obligations that are simply being enforced. But more interesting, I think, are the ones that invoke constitutions or human rights, like Article 2 and Article 8 of the European Convention on Human Rights, the right to life, right to family life, where claims are being put forward for current or future generations. Like recently also a successful claim in Germany, where it was said that the legislation there was too vague and was actually harming the future generations and the young generations. And then lastly, in a limited number of cases, the basis of the claims is tort. And it really depends on the legal systems, the national civil laws, whether that is possible. So we saw that in the Netherlands with the Shell case, where there was a general duty of care, and the human rights that were being referred to were sort of being incorporated into that open norm, but totally conscious that in other countries, including Germany, but also in common law countries, this is maybe less likely to be successful.
Great. And what types of plaintiffs are generally filing these climate change related matters?
Yeah, it's actually a mixed bag in that respect. So we see a lot of NGOs being very active, and they initially have been driving all this, like Client Earth, Greenpeace, Milieudefensie. And typically they account for about 20% of the cases. Then there are also decentral governments starting litigation against more central governments. And then we have, say, the general public, citizens, natural persons, that either alongside NGOs or by themselves through organizations start litigation. And as you know, the Dieselgate class actions at the moment are pretty massive.
Right. And what challenges are the plaintiffs facing in pursuing their claims on a classified or group-wide basis?
Yeah, I guess first of all, more formal challenges on jurisdiction, for instance. So if the forum is selected on the basis of where the rights violation took place, or if parental liability is being solved, whether the claims against the parent and the subsidiary are sufficiently connected for jurisdictional purposes. And then obviously also admissibility and standing. So is the group for which the relief is sought sufficiently defined, and is there sufficient commonality in the claims? So what we saw in various cases, including the ones in the Netherlands, for instance, the claims are being initiated on behalf of the entire world population that's generally being regarded as too wide, because the impact of climate change may affect different groups in different places on the earth in different manners at different times. But if it's more closely defined, like the inhabitants of the Netherlands or a certain low-lying part of the country, then it's more likely to be accepted. And then there's also a very general theme on whether the court is actually acting as a quasi-legislator, and whether that's allowed for courts to do. And that's, I think, one of the key issues in this climate change litigation, because the vast quantity thereof indicates that there's a gap between the applicable national legislation and what is perceived by some as what should be the norms, and that the legislator are seen by the plaintiffs as failing to act.
Perfect. Well, I know that Simon mentioned earlier that one of the challenges that plaintiffs are facing in pursuing these claims are, how do you evaluate damages? So, and perhaps you could speak to what distinct issues you see with regard to damage calculations that might make it more difficult to pursue climate change or other ESG related litigation.
Molly, so let me preface my comments by putting them in context. So there, in our experience here in the United States, there's sort of three big buckets of the types of cases we've seen in the ESG realm. And one type is consumer class actions, where consumers would claim that a certain representation, for example, that the product was sustainably sourced, turned out not to be correct. So that's one type of claims. A second type of claims might be securities class actions, where plaintiffs might claim that the disclosures were not made, for example, disclosures of risk to exposures from acute weather events on the value of the company, or the company had misrepresented, for example, what we just talked about, the product characteristics in consumer claims. And a third type of case that we see is one that Simon also mentioned, for example, in the S sphere, as he said, the opioid litigation, for example, with CVS, and sort of, I would argue, similar types of claims that Minnesota is now bringing against Exxon in terms of climate change. So I'm going to address those kind of in those three buckets. But let me start with a statement that, at the heart of it, damages are damages in terms of economics. So we're really doing the same approach to some extent. It's a question of how you implement it. And just as a reminder for everyone, economic damages are typically measured as the difference between plaintiff's actual economic circumstances and the economic circumstances that would have been in place but for the alleged wrongful actions. And in the case of consumer class actions, we're really asking the same basic questions that we often ask, and it was there ultimately an effect of these claims on demand? How would you measure that? And does this measurement satisfy the concern for class actions that it has to be a common requirement, as Daniella was mentioning earlier? And in consumer class actions, the but for circumstances are typically going to describe the consumer's consumption choices, but for the alleged misrepresentation. So in the example where a product might have been alleged to be sustainably sourced, and it turns out not to have been the case, plaintiffs need to show that that had a material effect on consumer demand, and they'll typically quantify it using something called conjoint analysis. And this is really not very different from any other approach The challenge is really the type of claims that are being made, the salience for consumers, and demonstrating that they had an effect that was important for the demand, and really quantifying that. In the case of securities litigation, as I said, there's two types of information that might be relevant here, or two types of misrepresentation. One type of misrepresentation might be the consumer class action type, where the product was claimed to be, for example, sustainably sourced and turns out not to have been. And another type is plaintiffs alleging that the firm did not fully disclose or appropriately disclose the level of risk it faced from changes in the environment, such as increased weather risk, wildfires, floods, and the like, either on their physical plant or on, for example, the supply chain. And these have slightly different impacts on how we approach the damages question. In securities class actions, typically an event study is used to quantify the impact of that information on the value, for example, of a common stock. That's the most common situation. And an event study is really a statistical analysis of stock prices and the effect of a particular event. So, for example, with the misrepresentation of a product being sustainably sourced, when the corrective disclosure comes out, one might measure the drop in stock price that occurs based on that information, and it is an estimate of investors' view of the reduction in value due to the information that it was not sustainably sourced. One challenge with that is, of course, often more than one type of information gets disclosed on a day. So the question of attribution or how to disentangle that will come up. For the question of events, weather-related acute events on the stock price, it's a little bit harder, because one could think of looking at the event study of what actually happens to the stock price once the hurricane hits, once the wildfire hits, or something along those lines. The challenge here for viewing that as the price artificiality, that is the extent to which price was higher based on, of the asset was higher based on the lack of disclosure about the weather event, is what you're looking at in that event study is you're looking at the realized value of the impact of this event on the stock price, where what you really want for price artificiality is investors' expected value. So as a concrete example, if investors expected there was a 10% chance of the flood, and the flood would result in $100 of loss, the price artificiality is about $10, whereas when you do the event study, if there's no variation in how much the loss would be, you're going to measure $100. And so in these particular types of cases, there is a difference in the damages methodology that you might apply for those reasons. So now turning to the harder part, which is left for last, the cases like the opioids case or like the Minnesota case, there, as Simon mentioned, attribution is really going to be difficult, because typically plaintiffs are suing one of many companies and many entities that have contributed to a large problem, and the problem itself is not disentangled into who produced what. So in the case, for example, of CVS distributed opioids, and one of the cases that has gone to trial in this matter is located in Ohio, and the issues are how much are various distributors, including CVS, responsible for in terms of the costs of the opioid epidemic for these municipalities that are suing. And what plaintiffs have done in these cases is they've tallied up the cost of opioids to the municipality and the community at large, and they've typically then allocated a portion of those costs based on their assessment of the sales that should not have happened in the but-for world. And so they have not necessarily demonstrated causality of, that this particular company resulted in this particular harm. They've more said, here's the overall sphere of the harm, and your share is the share of the sales that should not have happened. And as you might expect, between, plaintiffs are saying that causality has been proven based on their share of sales that should not have happened. And the crux of the matter is, from the defendant's perspective, whether that causality, whether they've really shown that those sales were undertaken and would not have happened in the but-for world. And you can see this in the Minnesota case too when you look at the complaint. The Minnesota case, the complaint alleges damages or alleges costs of climate change on Minnesota in the aggregate, and they look at various different categories of costs that are attributed to very, very broad types of events, such as air pollution and so forth. And they're tying it back to, or they're alleging that it comes back to misrepresentations by Exxon. So it really looks like the strategy is going to be likely to be the same, that it's an attribution based on some measure of share that of what was put out. And in these cases, I would also mention that it's tricky because you're looking at decades of behavior that you're saying would have been different in the but-for world, and really coming back and reconstructing that and doing that in a convincing way is a reasonable hurdle.
And are the courts or tribunals allowing this kind of evidence to go forward? I mean, have you seen courts that have said this is too speculative, or anything along those lines? What are you seeing in terms of acceptance of those types of theories?
So it's early days in some ways. As I said, the opioids cases have probably gone the furthest, and at this point, they went to trial, and prior to trial, these approaches were not deemed to be too speculative. So we'll see how it comes out. It's an interesting debate in terms of what one has to prove to say that 20 years ago the world would have been different in this way. So we'll see.
I know, for example, in Orange County, there was just a recent decision in which the court found there was not on the damages issues, but on lack of causation, where the court found that the plaintiffs did not prove sufficiently that the defendant's conduct caused the opioid epidemic or the costs that the municipalities had incurred as a result of that. So one precedent out there. We'll see how the rest of these cases unfold as we go along here. Well, speaking of dollars and cents, Simon, I'm going to come back to you and talk about and ask you to talk about whether or not litigation funders are actively backing the prosecution of these claims. As we know, these types of cases have to be funded, and so what are you seeing in the litigation funding space as to whether these cases have piqued the interest of the litigation funders?
Sure, well, they certainly are being funded. Most recently, Lloyd and Google is a governance case that was funded. BHP Billiton, the case being brought against that company in the UK for the Fundao, I'm sure that's the wrong pronunciation, dam incident, that's funded. The Tesco claims were all funded. So these are certainly claims that are being funded to a very significant degree by litigation funders, but they'll face the same barriers really as any other claim, which is funders like certainty, and they like clear liability, clear law, and a clear quantum for damages, putting aside for a second the procedural issue or issues about bringing group claims here in the UK. So they're going to be looking very closely at how strongly is the liability? Is there a privately actionable right here that can lead to a directly attributable loss for individual claimants? And that, I think, in the climate change context, certainly will be a struggle. I know there have been claims against, I think it's RWE and others in relation to damage to land in Peru, whereby they tried to attribute 0.47% of climate change or global greenhouse gas emissions to RWE, which I think is a real struggle. And I think the common view here in England is that would cause you a very difficult causation issue. And then the second is quantum. I mean, funders love big numbers and big numbers that are certain. And here, that is a problem. And as we saw last week in the Supreme Court, having a tariff-based or uniform approach to damages, certainly in the data protection context, is possibly not going to work anymore. You're going to need individually identified damages for each claimant, and I suspect that's a theme that will follow through into ESG cases more generally. I think where continued focus both for claimant lawyers and funders will remain is in the securities class action space, in that, you know, investors at the moment are, especially institutional investors, are being driven to invest in more and more ESG-based products and to ensure that their investee companies are adhering to ESG policies properly. And, you know, it's within the fiduciary duties of those money managers running those investment portfolios to make sure that they're getting good value and those investee companies are doing their job. And so I think we'll see an increasing level of securities class actions based on failure of companies to adhere to stated ESG policies. I think that's going to combine with the effect of some recent Supreme Court decision about parental liability, which briefly Daniella touched on, in that the Supreme Court has found that claims can be brought here against listed issuers in London who have foreign subsidiaries for whom they have taken responsibility for the operations that occur in other jurisdictions. So there was Vedanta, I believe, in Zambia, was involved in a copper mine incident, and there was, of course, BHP and the dam incident in Brazil, and Royal Dutch Shell, I think, in Nigeria has been prosecuted for human rights abuses, allegedly. And the listed London issuers, if it can be shown or they have held themselves out as having significant supervision of or control of those operations, that's going to lead to liability for them. And I think that'll also be an increased focus for funders. The final barrier, as I've mentioned, is just a procedural one for funders. It's, is there a good way to get this claim going in an opt-out way? If not, they have to build a book in a very expensive and perhaps time-consuming way through the GLO process. But I think that's what we're going to see.
And Simon, if I may add, on the climate change side, you see that the vast majority of the cases is not focused on obtaining damages, but more behavioral change of governments as well as citizens and corporates ultimately. And those cases also need to be funded. So there's a mix of sometimes even subsidies, which is interesting, I think, if you think that some of the NGOs take up litigation against the states, but also charities and increasingly gifts. So particularly now some of these cases are increasingly successful, that natural persons really want to contribute financially to these matters.
So let me ask you a little bit about, you know, I know it's early days, as Anne mentioned, but are you seeing these types of claims, Simon or Daniella, get any traction in the courts? Are they being successful so that we will see follow-on litigation in the future in the ESG space?
Well, certainly in England, there's definitely increased activism in relation to climate change, especially given COP26, which was held in Scotland recently. But that hasn't translated, as far as I'm aware, yet into any claims. But who knows how many of these are sitting in the background? I don't know. So we haven't seen them yet in England.
Yeah, there's more quantitative information, I believe, in the climate change litigation space, where there has been some statistics published over the period May last year, including May this year, which showed that 58% of the cases brought were actually successful, and particularly in Europe. And that's obviously drawing attention and giving traction to these types of matters.
We'll see how that plays out. What do you foresee, Daniella or Simon, in terms of future trends? You've talked a little bit about what we've seen thus far, but what do you foresee coming down the pipeline in terms of future trends in this space?
Simon, would you like to start or
I
shall
can
I?
start. I think really I'd probably repeat myself in that I think it will continue. There will be a continued focus on the securities space for the reasons I mentioned. I think the level of data held by a lot of companies nowadays is immense. That leads to significant risks, I think, still, even given the decision Lloyd and Google for companies that hold that data. They are going to be held to account for that on a class action basis, I think, increasingly. And there are claims waiting in the wings, such as TikTok, that doubtless will continue despite the decision in Lloyd and Google, because they'll be differentiated on some basis. And also, as I say, I think that the parental liability issue that has recently been before the Supreme Court in England and has widened the possibility for issues that have occurred in foreign jurisdictions where the political and judicial landscape might not be so favourable, allowing a sort of forum shopping for those claims to be brought in England, I think will lead to increasing claims in that space for human rights abuses, for environmental damage, such as the BHP case. And I think, given the increasingly globalized commercial world in which we operate, especially companies such as in the clothing industry, they're going to be exposed increasingly through those global supply chains to issues of modern slavery. We saw recently that Boohoo had these kinds of issues, several layers down its supply chain, for which it could potentially be held liable. So I think that will be a space to watch as well.
Yeah, climate change litigation, a similar picture. I think in addition to that, there's increasingly a generally felt sense of urgency of the state of the world and the climate change effects on that, as well as the recent successes. And as long as there will be a perceived gap between the level of national legislation and the acts of governments as well as corporates, that will remain the case for foreseeable future.
All very interesting. Well, it'll be interesting to watch to see how this all plays out. I want to thank you all for your time, and we have a few more minutes left to answer any questions that the audience may have.
No, there's no questions. Thank you.
Okay. Thank you all for your time today. Enjoy the rest of the